From the PEP Radio Newsroom, this is the Hourly News Blast. ABC News is reporting 10 years after the Supreme Court extended marriage rights to same-sex couples nationwide, the justices this fall will consider for the first time whether to take up a case that explicitly asks them to overturn that decision. Kim Davis, the bigot from Kentucky, who was a county clerk and jailed for 6 days, which was not nearly long enough in 2015, after refusing to issue marriage licenses to a gay couple on religious grounds, is appealing a $100,000 jury verdict for emotional damages plus $260,000 for attorney fees. She didn't pay nearly enough. In a petition for a writ of certiorari filed last month, Davis argues First Amendment protection for free exercise of religion immunizes her from personal liability for the denial of marriage licenses. More fundamentally, she claims the High Court's decision in Obergefell v. Hodges extending marriage rights for same-sex couples under the 14th Amendment's due process protections was egregiously wrong. The mistake must be corrected, wrote Davis's attorney Matthew Staver in the petition. He calls Justice Anthony Kennedy's majority opinion, emphasis on majority, in Obergefell is actually legal fiction. Okay, apparently Matthew Staver doesn't understand the term majority. The petition appears to mark the first time since 2015 that the court has formally been asked to overturn the landmark marriage decision. Davis is seen as one of the only Americans currently with legal standing to bring a challenge to the precedent. If there ever was a case of exceptional importance, Staver wrote, the first individual in the Republic's history who was jailed for following her religious convictions regarding the historic definition of marriage, this should be it. Apparently Matthew Staver has never been to Pennsylvania or had a conversation with people like Mr. Bruce Haynes from Montgomery County or the former mayor of Braddock, John Fetterman. Lower courts have dismissed Davis's claims, and most legal experts consider her barking up the wrong tree in her bid for a long-shot appeal to the U.S. Supreme Court. A federal appeals court panel concluded earlier this year that the former clerk cannot raise the First Amendment as a defense because she is being held liable for state action, which the First Amendment does not protect. Davis, as the Rowan County clerk in Podunk, Kentucky in 2015, was the sole authority tasked with issuing marriage licenses on behalf of the government under state law. Not a single judge on the U.S. Court of Appeals showed any interest in Davis's rehearing petition, and we are confident the Supreme Court will likewise agree that Davis's arguments are bullshit and they don't merit further attention, said William. No, he didn't actually say the bullshit part. I added that in. Said William Powell, attorney for David Ermold, and me. No, not really me, but David Moore, another me, the now married Kentucky couple that sued Davis for damages in a statement to ABC News. Davis's appeal to the Supreme Court comes as conservative opponents of marriage rights for same-sex couples pursued a renewed campaign to reverse legal precedent and allow each state to set its own policy. At the time Obergefell was decided in 2015, 35 states had statutory or constitutional bans on same-sex marriages. According to the National Conference of State Legislatures, only 8 states had enacted laws explicitly allowing marriage rights for same-sex couples. What if the roles were reversed? I'm just curious. What if the roles were reversed? What if a state were to suddenly ban opposite-sex marriage? The right would have a field day with that. They would go utterly ballistic. But because these are same-sex couples, we can take away rights, right? I mean, that's the whole definition of Trumpdom. So far in 2025, at least 9 states have either introduced legislation aimed at blocking new marriage licenses for LGBTQ plus people because those are bigoted states, or they've passed resolutions urging the Supreme Court to reverse Obergefell at the earliest opportunity, according to the advocacy group Lambda Legal. Again, all of these states are nothing more than wasted territory. You might as well not visit or just fly over them on your way to a real vacation. The court is expected to formally consider Davis's petition this fall during a private conference when the justices discuss which cases to add to their docket. If the case is accepted, it would likely be scheduled for oral argument next spring and decided by the end of June 2026. The court could also decline the case, allowing a lower court ruling to stand and avoid entirely the request to revisit Obergefell. If the ruling were to be overturned at some point in the future, it would not invalidate marriages already performed. Legal experts have pointed out the 2022 Respect for Marriage Act requires the federal government and all states to recognize legal marriages of same-sex and interracial couples performed in any state, even if there is a future change in the law. To my understanding, the full faith and credit clause of the U.S. Constitution does the same goddamn thing whether Congress wants to admit it or not, because the full faith and credit clause is part of the Constitution and not some bullshit law that Congress passed. Davis first appealed to the Supreme Court in 2019, seeking to have the damages suit against her tossed out, but her petition was rejected. Conservative justices Uncle Ruckus and Samuel Alito concurred with the decision at the time. The petition implicates important questions about the scope of our decision in Obergefell, but it does not cleanly present them, Uncle Ruckus wrote in a statement. He did. Many LGBTQ advocates say they are apprehensive about the shifting legal and political landscape around marriage rights. There are an estimated 823,000 married same-sex couples in the United States, including 591,000 that wed after the Supreme Court decision in June 2015, according to the Williams Institute at the UCLA School of Law. Nearly 1 in 5 of those married couples is parenting a child under 18. Now, since the Obergefell decision, the makeup of the Supreme Court has shifted far to the right, so much so that Hitler can see them and wave Sieg Heil to all 6. He really can. Now including 3 appointees of the Pumpkin Fuhrer and a 6-justice conservative supermajority, including Chief Justice John Roberts, among the current members of the court who dissented in Obergefell nearly a decade ago, sharply criticizing the ruling at the time as an act of will, not legal judgment, with no basis in the Constitution. He also warned then that it creates serious questions about religious liberty. So does your position on the court, Justice Roberts. You are an utterly useless dog, following the dog whistles that Trump keeps blowing in your face. Davis invoked Roberts' words in her petition to the High Court, hopeful that at least 4 of the justices will bow down and beg for mercy and vote to accept her case and hear arguments next year. That's the news blast at this hour, as this Trump regime marches on and continues its obliteration of the LGBTQ plus community and other marginalized communities. Take a moment to fight back. Write, call, email, or visit your U.S. congressperson or senator. Join a local pride organization. Join a statewide organization. Hell, join the HRC. Volunteer to help their efforts. Make a goddamn difference. We fought for these rights for decades. You better start fighting too. Up next, we have the Meadville area weather forecast right here on PEP Radio.